folks, and welcome back to Contract Law. This is video 3 in the series of videos on contents of a contract and exclusions, and in this video we are going to be looking at terms. We are going to look at when terms will be included in the contract between the parties and what they do when they are included as contractual terms. Obviously, everything else that falls outside of contractual terms for this particular video series is not going to be considered by us, but as I've said all along, that doesn't necessarily mean that if something naughty has gone on outside of the four corners of the contract, that you can't do anything about it. You do have those vitiating factors. Okay, so turning first to the question of when contract terms will be in as justiciable contract terms that you can enforce legally. Before everything else, the logical starting point is this objective test. You have to ask, would a reasonable person in the party's position have understood from the words, behaviour, conduct, whatever it is, that the thing, statement, would become an enforceable obligation. So you have this objective test. You have our lovely, familiar, reasonable person looking at what's gone on and saying, yeah, well, from all of that, what do I deduce? Does it look like the parties intended this thing, words, conduct, writing, to have contractual significance, or did they not? Why is this the logical first starting point? Because it goes hand in hand with the parole evidence rule. Remember, we said the parole evidence rule doesn't even come in to be applied if in fact it seems that there is something else out there in the surrounding circumstances that the parties have given contractual significance to, apart from the written terms, whatever's ended up in writing between the parties. Partly oral and partly written contracts, for example, won't attract the parole evidence rule. So that's why this is so important. You need to be able to work out, well, what's going on in this surrounding circumstances here. How do we work out what's in, what's out? Obviously, reasonable person has a look at it and says, yeah, that was promissory conduct, or no, that wasn't really promissory conduct. Okay, so you've got to have all of the main indicia of promissory conduct. You've got to have that intention to create legal relations there. Yeah, you've got to have your agreement and all of that kind of thing. Big red flags, though, that something will have contractual significance between the parties. There are 4 of them, okay? Time, reduction to writing, special knowledge and skill, and importance. Taking each of those in turn, firstly, time makes sense that the longer the interval of time between a representation and the actual concluding of the contract, the less likely that that representation is going to make it into, be nestled in with the actual contractual terms between the parties. It's much more likely that what has been said a long time previously is going to just be a mere representation that doesn't really have any contractual significance. That was absolutely the case. In fact, in these first 3 points, the case law tends to centre around, the main case law tends to centre around the sale and purchase of vehicles. In Routledge and Mackay, it was a sale and purchase of a motorbike, and there was about 7 days interval between when the representation was made about the age of the motorbike and when the contract for sale and purchase was actually concluded. And in those circumstances, given that a week had gone by, it was held that the representation did not make it into the contract as a term when it eventuated, as it always does, that the representation was not correct. The next thing to consider is reduction to writing. And there's a couple of inferences here that we can make, aren't there? If the parties are doing all of their negotiating, making representations during the negotiations, and then they take the trouble to sit down and write out their contract, there's an inference that all of the important terms have made their way into the written agreement between the parties. On the flip side, If there's something that's been said or done in the negotiation phase and it hasn't made its way into the written agreement, then there's a fair inference, isn't there, that it's not important enough to make its way into the written agreement as a contractual term. And that was one of the reasons why the court in Routledge and Mackay held that representation about the age of a motorbike was not contractual, because the parties had actually taken the time 1 week later to sit down and write things out, and that representation didn't make its way into the written agreement. The next issue is special knowledge or skill, and here we have a couple of cases that dealt with the sale and purchase of vehicles. In Oscar Chess and Williams, we had dear old Mr. Williams offering to purchase a rather saucy sounding Hillman Minx from Oscar Chess Limited, and as part of the deal he was going to trade in his old Morris. As part of the negotiations there, he told Oscar Chess Limited that the Morris was a 1948 model. In fact, it was a 1939 model, and someone had changed the logbooks. The previous owner to Mr. Williams had changed the logbooks rather naughtily, and so the trade-in amount that was provided to Mr. Williams was kind of overinflated because the car was older than everyone thought. What did you do? Obviously, in those days, 1957, you sue. It was found that Oscar Chess couldn't rely on that representation as to the age of the vehicle from Mr. Williams, because he had no special knowledge nor skill about that car. If anything, it was the car dealer. Oscar Chess was the car dealer, and it probably should have known better. So Dick Bentley is just a nice little bookend case to that one. Again, sale and purchase of a car. This time it was a Bentley car, rather expensive. Mr. Bentley was buying a Bentley car, and in that case representations were made about servicing of the vehicle and how many miles it had done, which turned out to be untrue. In that case, the representations were made by the car dealer, and it was held that, surprise, surprise, they were promissory in nature. They were contractual terms that Mr. Bentley could rely on and argue a breach and therefore get damages. So that is the issue of special knowledge and skill. The last red flag is importance, and where it appears that a representation is quite important to the nature of the deal, then it's far more likely that a court will find the representation to have contractual significance, and it will be a term of the contract between the parties. The hospital products and US Surgical Corporation case we had a little look at in terms of our discussion on the parole evidence rule. That was the case where you had this distributorship agreement that was being negotiated, and the distributor said that they weren't going to distribute other people's products, they were just going to distribute the US Surgical Corp's products. Obviously for US Surgical, that kind of a representation is going to be quite important, as I said before, because if your distributor's selling all your competitors' wares as well as yours, it's far less effective than if they were just selling yours alone. So that's part of the reason why the term, that the representation formed a term of the contract between the parties in that case. In fact, it was held to be, that term was held to be enforceable as a collateral contract, and we'll go on to look at collateral contracts in the next video. Harling and Eddy, Bannerman and White and EK are all just further examples of the same kind of point. In Harling and Eddy, I call it the Harling unhealthy heifer case. There was a heifer that was put up for sale, and there was no bids on this thing at auction. So there was a representation made that it was sound. You guessed it, it wasn't sound. In fact, the purchaser bought it when it had advanced tuberculosis. I didn't even know that heifers got tuberculosis. And because obviously that the health of the animal was very important to the deal, it was held to be a contractual term. So that is the test for when a representation will more than likely make it into the contract between the parties. So now we've arrived at the situation where the terms are in. they're in terms of the hokey pokey, they're not out. So what effect does that have? What do they do? What are the consequences? Here we need to turn to classification of terms. Here, I think you'll find in 20 years' time, when you look back to your law school days and you have a think about it, a few things you will remember from contract law. Number one will probably be Carlisle and the carbolic smoke ball case. Hopefully you'll also remember the issues surrounding offer and acceptance and classification of terms. Classic contract exposition here. Super important, because the way that a term is classified by a court will determine the nature of the remedies that you will be able to get for breach of that term. Okay, so super important here. Conditions are the essential provisions. I like to think of them as the skeleton of the contract. Without them, you just have this blob of flesh and it wouldn't be able to do anything.
Without bones, you would be just a puddle of skin and guts on the floor.
You actually have to have the bones in there at the very core of the thing to make it functional. Okay, so they are the really elemental parts of a contract. Because they are just so important, every single breach, no matter how slight, will justify the innocent party terminating the contract. Okay, and we'll talk about termination far more in depth in other videos in this unit. But particularly, damages will not be adequate to compensate the other party quite often where there has been a breach of condition, because they're just not getting whatever it is that they wanted to get out of the contract deal. So you might have one indicator of a term being classified as a condition if the actual contract itself says it is a condition of sale that blah, 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 blah. However, lay people will often use the word condition, I hate doing that, condition, to indicate just a term of the contract. Lay people don't necessarily attach the same amount of technicality to the word condition that lawyers and courts do. So whilst it is just one of many factors that might indicate to a court that a term will be a condition, it's going to be persuasive, but it's not conclusive by any stretch of the imagination. And there are two cases that you should know in relation to classifying a term as a condition. So in the tramways advertising case, we had Luna Park wanting to advertise its theme park on some advertising boards that were put up in trams. Okay, now in the contract there was a guarantee that each of the 53 advertising boards would be on the trams, and that the trams would be on the tracks at least 8 hours a day. So they'd be getting a guaranteed 8 hours of advertising per day per tram, and there was 53 of these advertising boards that were part of this deal. Obviously, tramways didn't supply the guaranteed 8 hours per day for each of the 53 boards. And what tramways tried to argue was a bit of a nifty two-step around the term of the contract. They said, oh, no. What we actually meant was that there was a guarantee that each of these boards was going to be in front of the public on an average of 8 hours per day. So it didn't really matter if one particular board was on the tracks for less than 8 hours, so long as on average it was on the tracks for about 8 hours per day. And that didn't suit Luna Park at all, considering the price it paid, and so they decided to litigate. The court there was faced with the question, was this guarantee about the 8 hours of advertising exposure per day, was that a condition or not? If it was a condition, obviously it would allow termination. If not, then you'd get damages at best. And so the court said It all depends on the intention of the parties. The test of essentiality is whether it appears from the general nature of the contract considered as a whole or from some particular term or terms that the promise is of such importance that to the promisee that he wouldn't have entered into the contract at all unless he had been assured of a strict or a substantial performance of that promise, as the case may be, and that this ought to have been apparent to the promisor. If the promisee wouldn't have entered into the contract unless assured of a strict and literal performance, he can treat himself as discharged upon breach, or if he entered into the contract in reliance on substantial performance, any substantial breach is going to justify discharge. That is the statement in relation to conditions that is constantly trotted out in texts and in judgments, and that is the statement that was then picked up and applied, you can see down the bottom there, in the case that everyone likes to talk about, which is Associated Newspapers and Banks. Mr. Banks was a popular cartoonist that drew the Ginger Megs series of cartoons. He contracted with Associated Newspapers to provide his comic strip called Us Fellas. Like I said, very, very popular. This was, the late 40s, 1950s. This ended up before the High Court in 1951. And in that contract, Mr. Banks required the newspaper, and the newspaper undertook to publish the Us Fellas comic strip on the front page of the comic section in the Sunday edition of the newspaper. It was very important for Mr. Banks to have his comic on the front page of the comic section, obviously best positioning there, and it was important that he continuously had his comic presented in this way, that his work was before the public in a certain way. And 3 times the Us Fellas comic strip was published on the 3rd page of the comic section rather than the 1st page, and Mr. Banks got very annoyed and purported to terminate the contract. So the question was whether the termination was justified and whether or not the undertaking by the paper to publish the comic on the front page was a condition or not. And in the course of the judgment, the court picks up the Tramways advertising test of essentiality and says, yes, actually, this term was so important to Mr. Banks that he would never have actually gone into the contract with the newspaper if he hadn't been assured of publication on the front page. So they are the 2 most influential decisions that you will find on the issue of whether or not a term is a condition. And now what we need to do is we need to talk about warranties. Until relatively recently, in contract law terms anyway, the only other kind of term that you could have in a contract was a warranty. So you had conditions, which were the skeleton, the really crucial parts, and then you had everything else. And I kind of think of warranties as, the muscles, all the other bits and bobs that are in a contract to kind of move it along and to get the parties the benefit that they wanted out of the contract. So they're subsidiary to the main purpose of the contract. And warranties can also, a bit like conditions, bear a number of different meanings. The etymology of the term warranty is basically indicates that a party is warranting the truth of whatever it is that's being represented. Generally speaking, if there has been a breach of a warranty, because it's not technically classified as a condition, you can't terminate for a breach of warranty. The best that you can do really is get damages. Cheval and the Builders Licensing Board indicates that, and also so does Bettini and Guy. Cheval and the Builders Licensing Board we discover in much more detail when we talk about termination, but in that case there was a series of breaches of a lease where the rent was just paid late or in parts, and the question there was, could that particular landlord terminate for the multiple breaches of the rent clause? They said absolutely not. The rent provision was just a warranty, not a condition, couldn't terminate. Bettini and Guy was just the same thing, different package. We had a contract that determined the terms and conditions on which a singer would provide services for a concert, and it stipulated that the singer was to arrive at a preordained number of days before the concert, and that term was breached. The question there again was whether or not it was a condition or a warranty. So warranties are all the other things, the muscles that move the skeleton around and get it to achieve what it was meant to achieve. That was the case, as I said, until relatively recently in contract law land, but in the 60s, 1962, we had the landmark English decision of Hong Kong Fur Shipping, and in that case, we discovered a whole new breed of contract term, and they started off being called innominate terms, but now we tend to talk of them as intermediate terms. I kind of call them the in-betweeners. So they're a little bit, they're not like the skeleton of a contract, and they're not like the muscles that are everywhere else. They're a little bit special. They're a little bit more like ligaments, and ligaments are kind of interesting because yes, you can damage ligaments in kind of a trivial or a minor way, but if you tear a ligament, wow, you are in real strife because there's no fresh blood supply there to help the healing process along. So with ligaments, you know, they can be trifling injuries or you can have really disastrous injuries, and that's the whole basis on which the court in Hong Kong Fur produced the classification of intermediate terms. What were the facts in that case? We had a ship that was chartered for 24 months, and it was supposed to be in every way fitted for ordinary cargo service. Unfortunately, it was not. The engine room staff was incompetent, including a chief engineer that was constantly drunk. The machinery was ancient and broke down, needed help, needed some maintenance crew there, but they were all clearly not doing what they were supposed to do in terms of maintenance. So there was about 20 weeks worth of repair. Obviously the charterers got sick and then sick of the constant delays and repairs, so they repudiated. The court held that the ship owners were in breach, but that seaworthiness was not a condition that would have allowed the charterers to terminate the contract. So whilst there were significant delays, they weren't so great as to frustrate the commercial purpose of the charter. So unfortunately for the charterers, they shouldn't have actually gone ahead and purported to terminate. When we talk about termination later on, we will find out that if you wrongfully terminate, that's called repudiation, and that actually allows the other party to terminate and seek damages, so it all gets to be a bit of a game. But so what should have happened in that case? They should have just sought damages. In that particular case, the court said it's not really going to help advance matters if we try and analyse this term as a condition or a warranty, because the fact is that the breach of this term could be either really trivial or it could be super, super, super serious. So it was a bit like an in-betweener, like a ligament. You might have, on the one hand, breach of this kind of seaworthiness clause, and you know, it might be a nut or a bolt that just needs fixing, and you know, it's done. All of a sudden the ship's seaworthy again. Alternatively, you might have disastrous events that flow from the breach of a seaworthiness clause. So because this kind of clause could operate like a condition or like a warranty, depending on the consequences that flowed from the breach, we have this new classification of terms called intermediate terms. The court said we have to look at the events which occurred as a result of the breach at the time at which the charter is purported to rescind, and decide whether the occurrence of the events deprived the charterers of substantially the whole benefit of which it was the intention of the parties, as expressed in the charter party, that the charterers should obtain. Now, if the breach was that bad, if the consequences were that bad, that it did deprive the charterers of substantially the whole benefit of the contract, it would be treated as a condition. Here it did not, and therefore it was treated as this new term, intermediate term, which in this circumstance, because of the non-severity of the breach, could only be compensated by damages, not by termination. So that is the new, relatively new, concept of intermediate terms. The only other thing that I really wanted to cover off in this video is just a couple of terms that you might see bandied about in the text, and you might be scratching your head and kind of going, what's that all about? Conditions precedent and conditions subsequent. Conditions, now here, classic example, we are using this term in the technical sense that contract law students should be using them. So these are terms that have a very significant effect on the contract, depending on whether or not they are satisfied. Sometimes you'll see texts talk about conditions precedent and conditions subsequent as contingent conditions. And these conditions will only pop up and become of importance on the occurrence of some kind of contingency, a contingent event. So for conditions precedent, it means that the contract won't come into existence, or it won't be born, if you will, until some contingent condition occurs. If it does occur, the contract will spring up. So one example of that was Pym and Campbell that we had a look at in the parole evidence video earlier in this video series, where you had to have the two engineers signing off on the appropriateness of that invention. That didn't happen. The contract never sprang into existence. Conditions subsequent mean that the contract will actually end or die if the condition subsequent occurs. Now, these are far more common. Examples of conditions subsequent is when you buy a house subject to finance. It means that you have a valid contract on foot, but if you are unable to secure finance, then the whole thing will fall over. They are the only other two points of clarification I just wanted to make for you. The only other thing I just wanted to remind you of was that if a term for some reason does not make it into the main contract as a provision in the main contract, so inspired by Meet the Fockers, obviously, this slide, it falls outside the circle of trust. It's outside the circle of terms in the main contract. You have this little odd thing on the outside there. What is that? It'll probably be a mere representation or mere puff. Because of the parole evidence rule, we'll just discount it. Okay. The only recourse you will have for something like that will be a vitiating factor. But if the thing that is outside that circle of terms in the main contract does in fact satisfy the test of intention, contractual intention that we talked about at the beginning of this video, then courts are going to look around for ways to enforce that term, and here is where you might find courts applying various different labels to that term in order to give it some effect at law. So you might find that the term is classified as a collateral contract that operates alongside the main contract. You might find that a court says that the term has been incorporated in some way, swept in by other mechanisms like notices or signs. So these two things we will look at next. And finally, in this video series, you might find that this odd little term that's left out of the circle of terms in the main contract might be implied, okay, and there are a number of different ways that a term can be implied. So that's where we're heading to in the last few videos of this video series. And that about wraps it up in terms of conditions, in terms of terms. So if you have any queries, let me know. Otherwise, we'll smash on to the next video. Bye, guys.